Hi, this is Burdick with Burdick International Realty Group. The Florida Association Exclusive Right of Sale Listing Agreement is the most popular type of listing agreement in the state of Florida. What this agreement basically says is that the listing agent gets paid a commission when the property sells, regardless of where the buyer comes from. Now, this is a good thing because this agreement gives the agent the most incentive to spend their time, money, and effort marketing the property. Another important thing about this agreement is that it allows the agent to market the property to all of the other agents in the area, and that way it exposes the home to a huge pool of buyers. If you're looking for a full-service marketing effort from your agent, the exclusive right of sale is really the only way to go. So let's take a look at it right now.
Okay, let's get started. At the top of the page, it's indicated that this is an exclusive right of sale listing agreement. This document was written by the Florida Association of Realtors. Lines 1 to 3 are very straightforward. They identify the seller of the property and the broker that's going to be marketing the property for sale. In Florida, only licensed brokers can list and sell property. Sales associates have to work under a broker and act on their behalf, so typically the broker's name and the sales associate's name will be in this section. The seller can be an individual, several individuals, a corporation, or pretty much any legal entity as long as there is an authorized representative of that entity. If the property is held in a partnership or by a married couple, all owners of record must be listed here. Section 1, lines 4 to 11, authority to sell property. This states that the seller gives the broker the exclusive right to sell the property and specifies the dates of the listing period. In Florida, listing agreements that are automatically renewed are not allowed. This section states that the agreement does not guarantee a sale and that there will be no discrimination against the buyer. Section 2, lines 12 through 20, description of property. This section identifies the property itself and any other items in the property that are going to be included as part of the sale. Section A lists the property address and the legal description. Section B details any personal property, including the appliances, that are going to be part of the sale. It also allows a checkbox if an attached list will be used. Section C states whether or not there is a tenant living in the property, and if so, when the lease term expires. Section 3, lines 21 to 34, price and terms. This lists the initial agreed upon listing price and some financing terms that the buyer can use that are acceptable to the seller. The financing terms in Section B state which types of payment the seller will accept, including whether the seller will finance the purchase or part of the purchase for the buyer and under what terms they will do so. In the rare case that the seller has an assumable mortgage, the details of this may be specified here. If the seller is willing to contribute towards the buyer's mortgage costs as an incentive, this is also specified here. It's important to remember when an offer is made on a property, all of these items are negotiable. For example, the seller can agree to include furniture instead of paying some of the buyer's mortgage closing costs, even if it's not indicated in the listing agreement. Section 4, lines 35 to 67, broker obligations and authority. Here the broker agrees to make a diligent and ongoing effort to sell the property. It gives the seller an opportunity as well to authorize the broker to do certain things and to choose to not have the property advertised in certain ways. In Section A, the seller can choose to have the property advertised on the internet, but without the street address being made available, or to not have the property advertised on the internet at all. This section must be initialed by the seller if chosen, due to the negative impact on the exposure of the property that this will have. Parts B through G state that the seller gives the broker permission to place signage on the property, obtain the seller's current mortgage information, put the property in the multiple listing service, and to report any information from the resulting sale of the property in the MLS, provide an objective comparative market analysis of the property to potential buyers, use a lockbox to show and access the property, and states that the seller releases the broker from liability if any loss occurs and that the seller acknowledges the lockbox is for the seller's benefit. This section also gives the broker permission to withhold verbal offers or to withhold all offers once the seller accepts a sales contract on the property. And finally, it allows the broker to act as a transaction broker. Part H covers what is known as virtual office websites, where brokers offer real estate services online. This allows the seller to opt out of allowing automated estimates of the property value to be displayed and/or comments to be posted online regarding their property. Section 5, lines 68 through 85, seller obligations. This outlines some of the duties that the seller agrees to. These duties are: A. Cooperate with the broker to help them sell the property, including referring any potential buyers to the broker. B. Provide the broker with keys to the property and make sure the property is available to show at reasonable times. C. Inform the broker before they lease, take out any new mortgage on the property, or do anything that encumbers the property, like liens, for example. D. Release the broker from any liability resulting from the seller's negligence and/or misrepresentations, use of a lockbox, any material facts about the property that the seller did not disclose to the broker, or any civil action that involves another broker's right to commission. E. They agree to comply with FIRPTA. This applies to non-U.S. citizens who sell property. F. To disclose all material facts about the property as required by law that affect the property's value. G. To consult a professional for questions related to their particular situation if they have any. In other words, don't ask your realtor for tax advice relating to the sale. Ask a CPA. Section 6, lines 86 to 104, compensation. Here is where the broker's compensation is specified. Part A shows the agreed upon total commission to be paid by the seller as a percentage plus any additional fee to be paid. Or if there is a flat fee commission instead of a percentage, this is where that's indicated. Parts B and C are reserved for commission paid if an option to purchase is received or if the property is leased. Section D outlines the circumstances when the commission is due. 1. When the property ownership is transferred. 2. If the broker brings an offer from a buyer at the price and terms in the contract, the seller is still responsible to pay the commission. 3. This section is what's known as the protection period, and it basically allows the broker to put in a specific time period where if the seller sells the property to a buyer that the broker brought to the table, then they are required to pay them the commission on that sale. Now, this doesn't apply if they relist it with another broker. This is basically to protect the broker from a seller stalling and selling the property to somebody after the listing has expired to try to get out of paying commission. Part E states that the broker can keep a percentage of any deposits made by buyers that the seller is entitled to, if that's indicated here. Section 7, lines 105 to 112, cooperation and compensation with other brokers. This section spells out that the broker will pay other brokers for bringing a buyer that ends up closing on the property, and it also indicates what type of agency relationship the agent must have with their buyer to get paid. Usually all of these are included because the seller and the agent don't really care. They're just happy to sell the property, so it doesn't really matter. This is usually also half of the total commission to be paid from Section 6, Part A, but not always. Section 8, lines 113 to 117, brokerage relationship. This section summarizes the relationship and obligations the broker has to the seller as a transaction broker for the seller. Section 9, lines 118 to 123, conditional termination. In Florida, the broker has the final say whether or not to release a seller from a listing agreement. This is described in this section. It says a seller must sign a withdrawal agreement and also gives the seller an amount they will have to pay to reimburse the broker for any expenses incurred or as a cancellation fee. Section 10, lines 124 to 133, dispute resolution. Here, the broker and the seller agree to try mediation to settle any dispute prior to a lawsuit, and it also gives both parties the right to agree to forced arbitration instead of a lawsuit in the case that they cannot mediate their issues. In forced arbitration, a third-party arbitrator, who is neutral, listens to both sides of the case and makes a decision that's binding for both parties. Section 11, lines 134 to 139, miscellaneous. This states that the contract can be assigned to another listing office and that faxes can be used and be considered as originals. Basically, the contract being assigned to another listing office occurs when an agent changes brokers and the broker agrees to release that listing to another party, when this prevents them having to re-sign an entire new set of documents. Section 12, lines 140 to 156, additional terms. This is where any other agreements or terms are made that aren't specified in the above sections. And finally, lines 158 to 167 are where the sellers and the broker sign and put their contact information. Now, it's not only required that the seller and the broker sign here on this page. If you notice also at the bottom of every page, there is a place for the sellers and the broker to acknowledge the receipt of the page and to initial as well. We hope you found this helpful, and it's difficult to cover all the aspects of this contract in a short amount of time. So if you have any questions about listing your property or how the agreement may apply to your circumstances, please give us a call toll free at 800-743-0271. Again, this is Chaz Burdick with Burdick International Realty Group, and thank you very much.